Today we are going to look at dispute resolution clauses. Lino and I did a session on dispute resolution clauses back in September 2022, but we thought that today would be a good time to revisit the subject on the basis that there's been two fairly significant developments which have arisen since we last did that webinar. And that is something which is called the Hague Judgments Convention 2019, which comes into force in the UK on the 1st of July 2025, and also the new Arbitration Act 2025, which actually received royal assent and came into force on Monday, the 24th of February. So it's quite a topical time just to look at dispute resolution clauses, in particular when you're dealing with cross-border agreements, so where you have counterparties who are based outside of the UK. Just before we begin, and just as sort of housekeeping, we are recording this session, and we will make a recording of the session available by email. We'll follow up afterwards, also with a copy of the slides. As always, if you've got any questions as Lino and I are going through the session, then please do include those in the Q&A box, and we'll try and deal with the questions at the end. And similarly, at the end of the session, there should be a pop-up just requesting some feedback. If I could encourage you to please provide any feedback that you have. One of the questions which is really useful for us to know is just if there are any topics that you would like us to cover in our in-house in focus series throughout the remainder of this year. So I think before we start to look at what we call Hague 2005 and Hague 2019, Lino was going to look at where we were in respect of dispute resolution clauses when dealing with EU counterparties.
Yes, so just as a quick refresher, the old regime was that the UK was part of something called Brussels Recast. So Brussels Recast provided a set of harmonising rules that determined which courts had jurisdiction. It also provided for automatic recognitions of judgments from one member state to another, and also provided that if proceedings are issued in breach of an exclusive jurisdiction clause, that member state's court had to then stay proceedings that had been issued in the wrong court and defer to the court where the proceedings should have been issued. Now, that regime does still continue to apply to claims that were filed in the UK courts before 31st of December 2020, but over time it's become less relevant. It's only ever going to have application now in a very limited number of cases, or if you've already obtained a historical judgment. But the reason for mentioning it is because it serves for quite a useful reminder that under this regime, things were automatic. So that meant that if you obtained a judgment in one member state, there was no process or particular recognition procedure that you needed to go through in order for that judgment to then become portable and recognised in another member state. You also had the certainty that other member states were going to apply exactly the same set of rules to determine whether one court had jurisdiction and not another. And so that would have impacted or placed a lot of emphasis on a jurisdiction clause if a party provided that for a jurisdiction in their agreement, it was to be interpreted that would be exclusive. On our departure from the EU, our preferred approach was to join something called the Lugano Convention. Now, the Lugano Convention operated in a way that was similar to what was the old Brussels Convention. It governed jurisdiction and enforcement of judgments between the UK and what we call the European Free Trade Association states, such as Switzerland, Iceland, and Norway. That didn't operate in a way that was automatic. You still had to recognise or have your judgments registered. But it did bring a level of consistency across the area. The UK submitted its application to accede to Lugano some time ago, and the EFTA states had all in principle agreed to that, but it requires everybody who's part of Lugano to agree, and the EU has not done that. There have been murmurings about whether the UK might rejoin Lugano, and it hasn't been completely ruled out. But for the time being, it doesn't look as if that's going to be on the horizon anytime soon. So where that takes us to now is the alternative convention that's in place, which is Hague Convention 2005, which Mark will come on to talk about.
Yeah, it's quite interesting. Just in respect of Lugano, the EU's position is that the Lugano Convention is there to try and help foster trade within the common market between the EFTA states, which from memory it's Norway, Iceland, and Switzerland, I think, Lino. Um, and I think what they're saying is that the UK isn't part of sort of a common market after we left through Brexit. And so therefore it doesn't want us to effectively join the Lugano because effectively that is there to try and help foster the mechanisms within a sort of a common market, which obviously the UK are no longer part of after having left through Brexit. So Lino's quite right. So in terms of where we are now, in respect of dealing with sort of EU counterparties, in respect to sort of dispute resolution clauses, and trying to find an effective mechanism where there is a streamlined process for enforcement of UK judgments in the EU and from the EU into the UK, is that effectively we are going to rely on something which is called the Hague Convention 2005. Just to summarize what the Hague Convention 2005 is, so effectively, if your dispute resolution clause in your contract falls within the ambit of the 2005 Hague Convention, what it requires then is that for any court that is subject to the exclusive jurisdiction clause specified in your dispute resolution clause, that court is obliged to hear that case. If there is proceedings brought in another court, they must refuse to hear the case, and that effectively the judgment of any chosen court from your exclusive jurisdiction clause is required to sort of be recognised and enforced in any other Hague Convention state, so any other state that has ratified it. And so at the moment, the EU, Mexico, Singapore, etc., have ratified the 2005 convention. So how would you fall within the ambit of the 2005 Hague Convention to get that sort of streamlined process? Well, what you need is you need your dispute resolution clause to specifically state that the court that you're choosing has exclusive jurisdiction to hear any dispute. It needs to be in the context of an international contract, so you need to make sure that your parties are from different different countries. So for that purpose, you couldn't have two French parties entering into an agreement that has an English exclusive jurisdiction clause to then take advantage of Hague. It would need to be, for example, a UK and a French counterparty to the agreement. In terms of sort of what's quite interesting at the moment is obviously just who has actually ratified the Hague Convention. I've sort of set out there sort of some of the key states who have ratified it. China and USA are both signatories to the convention, but they haven't ratified it. And so what that means is it's not enforced in the USA or China. In respect to the US, they were an early signatory to it, but there hasn't been any reported press in terms of what the US's position is to Hague Convention 2005 and whether they will ratify it. Obviously, that would be great if they did ratify it because it would mean there would be a streamlined enforcement process between the UK, EU, and the US. In respect of China, the position is slightly different, where the Chinese Ministry of Foreign Affairs has indicated a wish that it ratifies the Hague Convention as soon as possible. But that was a couple of years ago, and we haven't heard anything further from it. Just in respect of in the final bullet point there, I've got this point about there is a debate about when it applies. So the starting point is that the Hague Convention 2005 will apply to any contract that is signed after the Hague Convention came into force in the particular state where you're trying to take advantage of it. So there's a debate as to when the UK joined Hague 2005. The UK's position is that it's been a member of Hague 2005 since the time that the EU ratified Hague 2005, which was October 2015. There has been murmurings from the EU that actually its position will be that the UK joined it in January 2021 when the UK signed it and ratified it in its own right. And so it will be interesting to see how that plays out. I haven't seen a reported decision on that, slightly sort of esoteric. debate about when it came into force. I mean, ultimately, for those who are contract drafters on this session, it's fairly academic on the basis that obviously, if you're agreeing a contract now, then obviously that will be after January 2021 when the convention came into force. I just really want to quickly just touch on 2 points though about Hague Convention 2005 in terms of what we call asymmetric clauses and what we call carve-outs. So just in respect of asymmetric clauses, just to summarize what they are, that's effectively a dispute resolution clause where it typically says that the parties agree the exclusive jurisdiction of one court. However, one of the parties has got the option to go in any other court that it sees fit to try and enforce its rights. And so it's typical in banking agreements, so in facility agreements, where the bank usually wants to have the option of the fact that it can try and enforce its rights in any other jurisdiction where there may be assets. Um, there's a there is sort of a debate as to whether or not asymmetric clauses are permitted under Hague Convention 2005. Certainly, the position in the UK is over to comment in the Etihad Airways case, but that it's sort of perceived that it won't apply to asymmetric clauses. So if you have an asymmetric jurisdiction clause, then it seems that effectively what will happen is that you won't get the benefits of the streamlined enforcement process under Hague 2005, and you would have to enforce in an EU member state under local law. Similarly, in respect of carve-outs, what I mean for that is usually where you have a dispute resolution clause saying that the parties agree that the English courts have exclusive jurisdiction, but either party has the right to seek injunctive relief in any other court that it sees fit. And that's typical in respect of IP agreements, where effectively what you want to do is to try and protect your IP just in case that's being infringed in any other state other than where you have your exclusive jurisdiction clause. It's not been tested as to whether that would mean such a clause would fall outside of Hague 2005. I've had debates about whether it's enforceable. Some people consider it is, some people consider it's not. I mean, the ultimate issue is the fact that it's silent in something called the Hartley-Dugacci report, which accompanied the Hague Convention 2005, setting out what the drafters' intentions were. And so I think until that point is ultimately tested, I think we're just going to have to run the risk that if you need that carve out for injunctive relief in another court, then we would recommend that you proceed with that. But it just might be that when effectively you get a final judgment under an exclusive jurisdiction clause, that you might need to go under local law in order to enforce it. So Lino's now going to touch on something that's fairly hot off the press in terms of the Hague Judgments Convention 2019.
Yes, as Mark said, this is a this is a new treaty which is coming into force in the UK on the 1st of July 2025. The UK ratified this a year ago. This was one of the options alongside the Hague 2005 that's being discussed when as options for what would be in place if the UK couldn't get the benefits of Lugano anymore. Hague 2005 deals with choice of court agreements, and one of the limits of it, as Mark said, is that you need to have an exclusive jurisdiction clause in the agreement for it to bite. Hague 2019 is intended to is broader in its scope because it enables judgments obtained from one convention state to be capable of being recognised in another. But the importance of it is that it doesn't depend exclusively on having a jurisdiction clause to trigger it. Now, the aims of Hague 2019 are to try and create a wider global convention for the recognition of enforcement of judgments, and rather like the New York Convention that we have for arbitrations, which is, and its potency is to do with the fact that so many other states have ratified the New York Convention. At the minute, the Hague Judgments Convention is only enforced in the UK, Ukraine, and Uruguay, shortly to be enforced in the UK from July this year. It has been ratified by a number of other states, including Israel, the USA, and Russia. The position in the US is that judgments at the minute are enforceable. Cross-border judgments are enforceable in the US on a state-by-state basis. So, like with the position under Hague 2005, it's not clear how and when the US might ratify this convention. But obviously, if they do, that will then create one of the first structured enforcement regimes between the UK and the US. But it's not clear when that will come in. There are some quirks in that it's currently hasn't been ratified by any of the EFTA states, and for some reason, and I'm not entirely sure why, although the UK has ratified it, it only applies to judgments in England. So judgments from Scotland and Northern Ireland currently aren't caught by it. It will apply to English proceedings that are issued after the 1st of July 2025, providing that the country then wants to enforce it and has also ratified it. There are a number of gateways to recognise, to set out the potential for recognition for judgments. They include whether the defendant is resident or has its place of business in the state where they're part of the proceedings. If the contract contains a jurisdiction clause, and that can be a jurisdiction clause that's not exclusive, an exclusive jurisdiction clause would also bring Hague 2005 into play. If you have a contract, the place of performance of that contract is in England. If the defendant has submitted or consented to the jurisdiction, or the judgment relates to a contractual performance obligation where the place of the performance is in that state. It can also extend to certain other non-contractual claims as well. So Hague 2019 you can see, is much wider because it does not constrain a party from having to rely on an exclusive jurisdiction clause, but it does have its limits. So it's currently a narrow enforcement regime because it only applies to a handful of states, and it doesn't currently apply, despite the fact that the US having signed it, it hasn't yet ratified it. But it's better than nothing. Unlike the position under Brussels, the recognition is not automatic. So each state has its own processes for recognition. In the UK, that would involve making an application to have the judgment of the overseas states approved, and the way that would usually work is that there would then be a time period for that party to then challenge recognition of that judgment here. There are some grounds to resist enforcement, which are broadly similar to the grounds to resist enforcement under a number of other conventions. But a key one I would mention, or two key ones I would mention, is that recognition could be resisted if a party hasn't had the ability to take part of the proceedings within a reasonable period of time. And if there are proceedings or parallel proceedings, because there are no provisions in this in Hague 2019 to deal with proceedings issued in breach of a jurisdiction clause being staged, you can have a situation where a judgment from one state could find that it then conflicts with judgment in another. It also doesn't extend the definition of what is a judgment also doesn't include an interim judgment. So again, in keeping with quite a lot of other conventions, but in order for a judgment to be recognised or capable of recognition under this, it will need to be a final judgment, and it would need to be a judgment for a monetary award. Mark is going to come and talk about what the position is going to be if you don't have the benefit of either Hague or you have a counterparty that's out of the EU.
And so ultimately, where we are now with Hague 2005 and Hague 2019 is that it's probably the best world that we could have been post-Brexit in terms of having sort of a streamlined process for enforcement of a judgment from the UK into the EU and vice versa. Ultimately, though, if you don't fall within the ambit of Hague 2005 or Hague 2019, then you are going to have to rely on the local law procedures. And that is the same in respect of outside of the EU in other territories, where effectively there isn't a convention or some form of legislation which allows for a streamlined process of enforcement. And so I think if you're dealing with dispute resolution clauses in respect to counterparties or where you think there are assets based in a jurisdiction outside of the UK, we would sort of stress that you need to think carefully about what dispute resolution clause to choose. And so I've given an example there on the slide around the position in Kuwait. So the position in Kuwait is that they will enforce a foreign judgment provided that you can prove that there's what we call reciprocity between that state and Kuwait. So what that means is there evidence that the UK courts will enforce a Kuwaiti judgment. And in respect to Kuwait, sort of my understanding is there isn't a reported UK case of a Kuwaiti judgment being enforced. And so that means that it's probably unlikely that a Kuwait court would enforce a UK judgment. If you take the UAE, for example, very relatively recently, over the last couple of years, there has been a UK judgment that has enforced a UAE judgment. And so therefore the UAE courts have started to enforce UK judgments under its local procedural law. There are sort of various quirks, however, within sort of enforcement regimes around the world where you can try and take advantage of it. One of the things I've mentioned there is that, for example, if you are dealing with a GCC country, a counterparty in a GCC country, one of the things you might want to consider is what we call the DIFC courts in Dubai, which is it's a common law system. It's based on the English civil procedure rules, and it follows sort of it largely adopts English law. There used to be a waterfall actually where it said that if DIFC law is silent, English law will apply. And so therefore, if you want something which is akin to English law, which will give you confidence in terms of how your dispute will be resolved, but you actually then want to have sort of a fairly streamlined mechanism for enforcing such a judgment, the DIFC in that case may provide you with that comfort, given what we call the DIFC Memorandum of Understanding, and the way that that can then be enforced through the Riyadh and GCC conventions. I think ultimately, though, if you get to a position where it's not clear that a UK court judgment or a judgment of another of another state is going to be easily enforceable in a particular country, one of the things you might want to look at is arbitration. And so, for those of you who aren't sort of that knowledgeable or with arbitration, really all arbitration is it's a private form of dispute resolution. Effectively, the parties choose their arbitrators. If the parties can't agree on who the arbitrators are, then there's usually, certainly in the UK, there's a default provision under the Arbitration Act for the court to appoint the arbitrator. Typically, if you've chosen institutional rules to govern the arbitration, then that will have a default rule about the arbitration centre to appoint the arbitrator. Arbitration in the UK, it's an implied term that it will be confidential between the parties unless they've expressly agreed otherwise. But really, the main advantage of arbitration is something called the New York Convention, 1958, which provides for a worldwide it provides for a worldwide mechanism for the enforcement of arbitration awards around the world. As said, there's 172 states who have ratified the convention. There is no other convention around which provides for such a mechanism of trying to enforce effectively a judgment, in this case, an arbitration award, from one state into another. You'll be fairly hard pressed to find a jurisdiction that has not ratified the New York Convention. As I sort of highlighted at the start of the session, we have just had the Arbitration Act 2025 come into force on the 24th of February 2025. That has made some changes to the arbitration regime in the UK. I've called it there on the slide. It's an evolution rather than a revolution. What it's trying to do is to sort of resolve issues which have emerged since the Arbitration Act 1996 came into force. And I think just conscious of time as well, I think in terms of sort of key takeaways that you probably should be aware of, I'll take the first the first, second, and fourth point there on the slide. The first point is is what we call the law which governs the arbitration agreement. So I think hope so for those who don't know, in terms of how the arbitration agreement works, the arbitration agreement is treated as a separate contract within your underlying contract. So it has effectively a regime of its own. And so in recent years, there have been various cases which have had to grapple with the issue about what law governs the arbitration agreement itself. Is that the same as the law that governs the substantive contract, or is it a different law just to the arbitration agreement itself? And so we ended up with a Supreme Court decision called Anchor and Chubb, which said if it's silent as to what law governs the arbitration agreement, effectively the default position will be that the parties have agreed the governing law, which is in the underlying substantive agreement, that law will be the governing law of the arbitration agreement. In France, for example, the Court of Cassation has ruled differently and said no, it will be the law of the seat of the arbitration, which is the law which governs the arbitration agreement. And under the Arbitration Act 2025, is going to reverse the Anchor and Chubb decision and impose effectively the same position that they have in France, that it will be the law of the seat. So the governing law will be the same as that of the law of the seat. I think probably the most interesting aspect is that the what we call the new power of summary disposal. So that's it's this is whether or not tribunals have got the power to effectively provide summary judgments where you've got a hopeless claim or a hopeless defence in your arbitration proceedings. The power has always been there under the 1996 Act, but what they've done under the 2025 Act is actually just provide an express power, allowing for tribunals to summarily dispose of claims which have no merits. I think that's sort of particularly sort of interest to banks who have been sort of adverse to using arbitration because they don't think that it has the same summary disposal mechanism which you have, for example, in English court litigation, where you have the summary judgment regime. I think the word of warning I would provide, however, though, is just looking at it in the context of the Singapore International Arbitration Rules, where they have, since 2016, had a mechanism to allow tribunals to summarily dispose of claims which are hopeless. And so, looking at the annual reports issued by SEAC, they report each year on how many times that regime has been used. And so, just looking at the most recent report for 2023, so in 2023, there was over 660 cases filed at SEAC. The summary disposal regime, there were 9 applications for summary disposal. And then when you break down into that 9, only 3 actually proceeded, and only one of those was successful. One was rejected, and one was withdrawn. So you can see it that under the SEAC rules, whilst they've had this power of summary disposal for some time, it isn't actually used that often. And I think that's probably because parties are still nervous of the fact that tribunals will do whatever they can to make sure that their award is enforceable, in particular whether it's enforceable overseas, and so therefore will want to make sure that they're seen to be achieving that justice has been done between the parties, and so allowing cases to proceed to a final merits trial, even if the tribunal has concerns about whether or not there's such a merit in a claim or within a defence taken in the arbitration. And again, just the final point I had there on the slide is what I call the Section 44 powers. So the Section 44 powers are powers of the English court that they have to try and aid arbitration proceedings, whether in this jurisdiction or overseas. They've amended that provision to say that it actually the court's powers extends to non-parties to the arbitration. And so what that means is that it reflects the Court of Appeal decision there in A and C that I put on the slide that confirmed that the Section 44 power is extended to non-parties. But what it does now is it puts on a statutory footing that you can seek relief from the English courts to obtain evidence in support of an arbitration from third parties who are domiciled in the jurisdiction, or to try and protect assets in furtherance of trying to enforce any arbitration award. in the future. So for those of you who are looking to adopt arbitration clauses, I've put there some sort of top tips in terms of how you should approach it. The first point is that it needs to be in writing. And then if it's 11 p.m. at night and you need to get an agreement signed and you just can't get hold of, a lawyer, then the LCIA, the ICC, etc., they have model arbitration clauses on their websites. So I would encourage you to at least use that as the bare minimum. And those provisions always cover the must-haves there that I have on the slide, in terms of specifying where the seat of the arbitration is, how many arbitrators you want, and what the language is to be used during the arbitration. I put there sort of other considerations of what you might want to consider. The first I have is, do you want to add a carve out within your arbitration agreement to allow for you to go and approach the courts for injunctive relief? We've sort of I raised this issue because there is an issue which has still been out there since this case called Gerald Metals in 2016, which hasn't been remedied under the Arbitration Act 2025. And there's a debate as to whether or not the English courts will step in to provide injunctive relief if the arbitration rules that you have specify what we call an emergency arbitrator regime. So in Gerald Metals, the court found that it wasn't going to give injunctive relief because the party in that case could go and get emergency arbitrator relief under the LCIA rules. The second point I have there is, if you've got parties who are from different countries, certain of the arbitration rules, so the LCIA, the ICC, specify that if you've got parties from a different country, unless the parties have agreed, the arbitrator who is to be selected, so if you have one arbitrator, the arbitrator to be selected, or if you have three, the chairperson of the tribunal will have to be from a different country from those of the two parties. So if you have a UK counterparty and a French counterparty, unless the parties agree, you can't have an English arbitrator or an English chairperson. And that does create headaches, especially where you have English counterparty enters into an agreement with a French counterparty, they specify arbitration, and then they have an English law governing clause and arbitration agreement to be seated in the UK. And so therefore what you've done is you're trying to find somebody who is UK qualified to be an arbitrator, but you limit the pool because you can't appoint a UK national. And so therefore what we should recommend is that if you've got a situation like that, is you might actually just want to disapply those rules so that you can select an English arbitrator. And then the final point there is actually, do you just want to specify which law governs the arbitration agreement? Whilst that position has been resolved under the 2025 Arbitration Act, certainly around the world, this debate that's come out of ENCA and Chubb, the Supreme Court decision that I referenced, is still going to be ongoing. So just legislate against that risk now by just specifying what law it is that governs the arbitration agreement up front in your arbitration agreement. So I think Lino is now just going to try and bring that all together, just in respect of sort of drafting top tips when you're looking at dispute resolution clauses.
Yes, thank you, Mark. We're just going to conclude with some overarching points, as Mark said. Often when it comes to drafting jurisdiction and dispute resolution clauses, is you often need to think about where you want to end up when deciding what you need to put in at the beginning. The key point normally is to think about where you're going to need to enforce the judgment if things go wrong, because there's no point in taking enforcement steps or taking any steps to obtain a judgment or order against somebody if it's not going to be worthwhile. Typically, that often means thinking about where your counterparty is based and how you might be able to enforce whatever you want them to do. That's often about thinking where their assets are, what remedy you might want. Most of the convention and local law provisions that limit the scope to enforce anything other than monetary awards. So if you want to, if you have a contractual arrangement where you want to secure order for something other than money, you may need to think about whether or not the terms of your jurisdiction clause or your dispute resolution clause might need you to involve taking proceedings overseas. You might also want to think about the procedures that some of those overseas countries adopt as well. Mark gave a very good example earlier about the ability to be able to get a summary disposal of claims in England. We have a very effective summary judgment regime in England, but not many other jurisdictions necessarily have that. A number of European jurisdictions, for instance, do not have the equivalent of a summary judgment process. We also have a very disclosure-heavy process in England, or cards on the table approach in England, and a very adversarial process. Some other jurisdictions, their processes may be more streamlined than they are in England, so you may want to think about where witnesses and evidence would be based if you ended up having to enforce your rights there, and ensuring that if you have a jurisdiction clause that actually allows you to be able to do that. Some countries have very powerful interim protective measures as part of their litigation process, even in countries in the EU. So, for instance, in the Netherlands, in Malta, it's relatively straightforward to get the equivalent of an order freezing the assets of a potential defendant. The test for doing that is the bar is actually quite low compared to our ability to be able to do that here, where you effectively need evidence of dissipation. The ability to be able to get freezing orders in aid of proceedings in the UK is not almost exclusively related to claims in fraud, but they are very difficult to get. And so it might be that you want to think about whether in the drafting of your dispute resolution and jurisdiction clauses, whether you may actually want to still reserve the right to be able to go overseas so that you can take the benefit of some of these. Often a difficulty with any form of jurisdiction clause is that it tends to have to be, once the provision has gone into the agreement, it often ends up needing to be a one size fits all. One size fits all doesn't always work in contractual agreements. We can't necessarily predict what disputes might arise, but critically, the one that often trips people up is that if you have a contract with a party overseas and you have a debt claim, and you have a jurisdiction clause that provides for exclusive jurisdictions for the English courts, you may actually make it quite hard to enforce a relatively low value debt claim. There may be no easy answer to that, because although you can draft jurisdiction clauses that attempt to carve out or limit it by reference to the type of claim that you bring, disputes relatively rarely pigeonhole themselves to one specific issue. Often, the only easy way to deal with issues like debts is to actually put provisions in the agreement that allow you to either withhold payments, apply for service credits, set off or delayed payments, etc., things like that, which limit the scope for you having to take steps to enforce debts through court proceedings. In terms of where you're dealing or who you're dealing with, Mark and I have talked about different conventions that apply, but broadly speaking, the convention regimes or treaty arrangements that we've currently got are only limited to a handful of countries. We can generally expect a level of cooperation from EU and EFTA states or former Commonwealth states. And so if you have arrangements where with or contracts involving counterparties in one of those jurisdictions, you would hope or expect that judgments eventually would become enforceable. If you are dealing with a more exotic location, may well be that arbitration is a better option, and so the focus ought to be on drafting an arbitration clause rather than a jurisdiction clause. If you have a governing law clause, this sounds like a very basic point, but it often makes sense to have a governing law clause and a jurisdiction clause as the clause that matches. A question as to whether or not you should pick exclusive or non-exclusive jurisdiction clauses as position has probably softened a little bit more now since the introduction of or the application of Hague 2005 and Hague 2019. The only guarantee you have if you have an exclusive jurisdiction clause is currently Hague 2005, and that will change from July onwards. And so when deciding whether or not to have an exclusive or a non-jurisdiction exclusive jurisdiction clause, there is a bit more flexibility now that is available to you. Exclusive jurisdiction clauses tend to lend themselves to contracts where you want control over where the proceedings take place, and you have a counterparty overseas, and you want confidence that a judgment will be recognised where the assets are. But what they don't necessarily allow you to do is to go away and get interim relief very easily. They won't necessarily allow you to take proceed or obtain proceedings in another state where you may not want a monetary, where we want something other than a monetary award. So non-exclusive jurisdiction clauses tend to give you that more flexibility and more scope to go abroad, particularly if you want an interim remedy or a non-monetary award. If you want interim relief, as Marcus discussed the issues of carving out, we'd always recommend that you consider getting local law advice if you are going to want interim relief, because none of the current conventions really cover interim relief at all. The position was slightly different when we were part of the EU, because you could generally expect that a level of cooperation over interim remedies, but the position is simply now going to be on a state-by-state basis. If you have contracts where you've got a chain of contracts, so supply chain being a good example, you need to try and ensure, to the extent you are able to make sure that the dispute resolution clauses and jurisdiction clauses are consistent throughout. There are conventions that said Hague 2005 and Hague 2019 that will allow scope for judgments to be enforced and for cooperation. The trouble is, one of the exceptions to enforcement under Hague 2019 will be if there are other courts that are already seized of the claim. And certainly there's more scope for parallel proceedings. It's very difficult to find an answer to that, other than to try and ensure you've got back-to-back arrangements. But sometimes that may not be possible. But that is what we would recommend. If you have arbitration, Mark says, think about the institutional rules. If you don't provide anything other than arbitration, you will have something called what's called ad hoc arbitration. So there's quite a lot of other things to think about in terms of which arbitration rules to pick, how many arbitrators, etc. And finally, if you've got a dispute resolution clause that's got various steps or tiers to them, it is important that those are clear, and that if you have them, that they're followed. In England, the courts are a bit more willing to depart from or hold people to dispute resolution clauses, particularly if you're up against a time limit. But they are critical if you have an arbitration clause. If you have an arbitration clause in your agreements and you haven't followed the dispute resolution provisions and they're not clear, or there's an argument about whether they have or haven't been followed, it's possible the tribunal may not have jurisdiction in the first place, and you end up with an award that's unenforceable until those steps have been completed.
Perfect. Thanks, Lino. Just conscious of time, there's been a couple of questions that have come up. Lino, I think if I just take this one, which is around sort of recommendations in respect to dealing with Chinese counterparties. Again, not sort of making a recommendation as such, but just to let you know sort of a bit of the lay of the land in terms of what we've heard. So that in respect of whether an English court judgment would be enforced in China, that there has been a law firm has reported that there is an unreported case in China where a Chinese court has enforced an English court judgment. But I think realistically, until that becomes a common practice, we probably wouldn't recommend an English court jurisdiction clause if the only assets that your Chinese counterparty has is in China, and so you'd be looking to enforce in China. If they've got assets outside of China, then you might want to look at whether UK court would provide you with an enforcement route over those assets in whichever territories that they're based in. I think the one thing sort of I would encourage people to look at, if in that scenario, is Hong Kong, and in particular the Hong Kong International Arbitration Centre, just because that will give you something which is sort of familiar to dispute resolution in the UK, on the basis that Hong Kong is a common law jurisdiction. But then there is something called, I think it's the Memorandum of Understanding between mainland China and Hong Kong about the reciprocal enforcement of arbitration awards from Hong Kong into mainland China and vice versa. And so therefore that might actually provide you with the bite that you've got your enforceability aspect underneath that memorandum of understanding. Again, we're just running slightly over 10:45, so we'll end the session there. Just in respect to the other questions, we'll try and follow up by email with those people who've asked the questions. As I said at the outset, there is a pop-up with hopefully with asking for some feedback. If you could fill that in and just explain if there are particular topics that you'd like to hear more about, that just helps us in terms of planning the In-House in Focus series for the remainder of the year. The next webinar in the series will be on the 19th of March. It's looking to actually be a really interesting session which talks about the AI Act, which has been enforced in the UK since the 2nd of August 2024, but then looking at that in the context of EU law on artificial intelligence. And so we're happy to have Sven Erik Holm, who is joining from the German law firm Graf von Westphalen, and Peter Wayman from our Cambridge office, who are going to look at effectively how the regulatory regime for AI works between the UK inside and outside of the EU. That's all for today. I'd just like to say thank you to everybody for joining. I hope that session was useful. Again, if you've got any questions about anything that we've discussed, or if there is something which you need advice on in respect of dispute resolution clauses, then please don't hesitate to contact Lino or me. In the meantime, have a fantastic day, and thank you very much. Take care.